Yes, welcome to the No State Project here on my YouTube channel. It is No State Project. Glad to be with you here from the fortified compound in Mesa, Arizona, where we are every Wednesday from 3 to 6 Eastern Standard. Well, 3 to 6. I'm really messing this up. No, we are here from 3 to 4 Pacific Standard Time. And glad to be with you here. Got a lot of stuff to get to. I guess I'm expecting a lot of calls today. So if you want to give us a call into the big show, you can do so at 218-632-9399. 218-632-9399 is the number for you to call to join me on the big show. The passcode, of course, is 2020 with the pound sign. So 2020 with the pound sign or the hashtag. Skype, not as easy on this particular broadcast, but you can instant message me first. So just use Skype to call. But if you want to just ask me questions during the show, it's Frank Rizzo 3. That's Frank Rizzo with the number 3. So, yeah. But it is episode 72, the big broadcast. I do want to thank again good friend Bill and Dan in New Hampshire for the continued support of the big show. So today's show and the next few shows are going to be brought to us by Bill and Dan. So if there are 1,000 more people out there like Bill and Dan, because Bill, especially Bill, is he's been on the show, and I definitely recommend you going back into the archives about the tyranny in New Hampshire, where we detail a lot of. I actually have pictures of some of the bureaucrats that were involved with that, but he gives us a really good report regarding what he had gone through. And for those who say I don't talk about when things go bad, well, that's just a flat out lie. It's absolutely not true. And this is just one of those examples. I won't say that we talk about a lot of train wrecks on the show because we don't get nearly as many train wrecks as we do success stories. But there is a lie that I cherry pick and I only discuss when things go well. And that is absolutely not true. I wish, things did go better. But we are dealing with criminals. So, yeah, you have to take that into consideration. And when I say that they're criminals, it's because they are men and women that are forcing strangers to give them money. So that makes you a criminal. That's the way it works. It's not my morality, but it's something that we all tend to agree on, because from a standpoint of self-interest, we don't want to get hurt. So to be morally consistent, in that, we extend that to other people. Plus, of course, we do have the whole empathy thing, and we don't like to see other people get hurt. We don't like to get hurt. Well, what happened with Bill with the White Mountain Country Store there in New Hampshire, yeah, just an absolute tragedy. And but he put up a hell of a fight. The admissions that we got there, that's one of the bittersweet thing. They admittedly had no evidence, and of course, it didn't stop the attack. They just wouldn't stop. So eventually, yes, you have to cut your losses and you have to walk away from the fight if you are able to do that. And there's no shame in that, especially here when you have admissions from so many bureaucrats. Yeah, and of course, it was from Bill's situation where Desjardins, the judge. So if you remember in the pictures, so definitely go to the video to see the pictures of this guy. He has the bowl cut. It's the Dutch boy haircut. And so the quote that I use a lot because is because he was one of the more recent ones to say it. Jurisdiction's a pure issue of law. It requires no evidence to prove it's true. All the prosecution has to do is show that you're physically in New Hampshire. Okay. Maybe the stupid bowl cut blinded him from the obvious contradiction that the man had just given. But one of the things I want to talk about before I get into calls, because I tend, I like to look at not individual politicians, but I prefer to look at the cult of personality that surrounds them, and that for some reason that people even though there's all the jokes that how do you know when a politician is lying, his lips are moving, he's communicating in some way. It just seems to be that certain cult of personality around certain, particular politicians is so absolutely strong. The bond that people have, or at least act as if they have, is so extremely strong that I think I mentioned on the show a few days ago on the Saturday show, and it is July 18th today. Yeah, I'm gonna get to the calls in just a second, but I wanted to take a few minutes and discuss this. The best that I can do in this short period of time is to look at the sunk cost fallacy, and having to do with you have so much invested in a particular ideology or into a particular individual that no matter what happens, no matter what they say, no matter what they do, like an abusive spouse, you will not stop supporting them because it's just like having a piece of crap car and you've sunk so much money into it. I can't let it go. I know it's going to fall apart. I know it's a piece of crap. I know I'm going to have a problem again next month. I can't let it go because I've got so much invested in it. And that seems to be more true for this latest figurehead. I don't know if it's even accurate to say that, given everything. But I think I mentioned on the show that Donald Trump could walk down Pennsylvania Avenue, shoot a child in the face, and he would still be defended. Still be defended. Well, yeah. And just, they would say, look what Hillary did. What about Hillary? So it doesn't matter. It's just so the only thing I think that explains is the sunk cost. People don't want to admit that they put their trust in them and gave their money to an individual that is so loathsome, so dishonest, that they just can't give it up. This whole thing, he says things the way they are, but are they true? Are they really true? Gosh, I tell you. It's sunk cost fallacy. That really kind of explains it. I've got so much invested in this guy that no matter what he says, no matter what he does, I'm going to continue following him. And where do you see that in other parts of life to such a degree, other than politics? Really is disgusting. Really is absolutely, the idea that somebody can do and say and get away with what politicians, especially this one, and people just continue supporting. Although I will say, even Fox News has called him out on that. So maybe that there's a turning point. Maybe there's going to be a break, that maybe there's going to be a mass exodus. People are not going to support this lying, narcissistic piece of garbage anymore. And then they can turn to the next lying, narcissistic piece of garbage. But at least, I don't know, maybe people will learn something here, that to look more at the policy and not the man. I don't know. Hey, how about looking at the morality of it? How about looking how wrong it is to force strangers to give you money for whatever purpose? We shall see. But let's get to the calls, because I think we've got a report from somebody who was in court today. We have area code 401. What's your name? Where are you calling from? Oh, you got to be kidding me. I'm getting no audio. I've got no audio at all from the caller, so I don't know if you can.
Can you hear me now?
Hey, I can hear you now. So, so what's your name? Where are you calling from?
Sean, Melbourne, Florida. Just had court today.
All right. Well, somebody told me this is going to be pretty good, so give us the details.
All right. So basically, I have court for expired tags. I have 9 tickets total, 8 of which are by the same cop. But anyway, my second arraignment attempt was today. And I went back to the evidence of jurisdiction, what the prosecution has submitted, and the judge basically said that they don't have to prove jurisdiction. They have it. And I, of course, asked the questions. Go ahead.
Well, I was just saying, wow, that's okay. They don't have to prove jurisdiction. They have it.
They're assuming they have it.
He used the word assumed.
That's fine. I'm not sure, but I asked the judge what factual evidence she relied upon, and she's like, "We have jurisdiction because you have a license." And this is in two parts. The first part was with people in the room. The second part was with no one in the room but me and her. And she asserted that the license was evidence of jurisdiction. So I asked the question, "So if I didn't have a license, you wouldn't have jurisdiction?" Her response was, "Yes, we would."
Okay. Did you have her expand on that? And because you could be asking a leading question there that brings out that the license, given her own statement, the license is irrelevant to whether there's jurisdiction or not.
I actually did. I asked her when she said that, if you have jurisdiction either way, what relevance is the license? She disregarded that question and went to, well, if you were physically within the state.
Okay, she went there. Okay.
And after that, I didn't get too many questions in before the subject of filming got brought up, in which case the first part of it, I was dragged out and held in the back. A bunch of nice sheriffs back there, by the way. Totally good hour-long conversation with them. And I get back to the courtroom, and this is just me and her. No one else is there. So it's actually turned into more of a one-on-one conversation. And she kept asserting the same things. And I asked her, because she said I was physically within the state. I'm like, factually, Mrs. Ingram, what is the state? And she's like, the borders. You're within a border. I'm like, so the border is the plaintiff to the case?
And how'd she respond to that?
She dodged that question also. She said at that point, you have a license, you were within the state, we have jurisdiction. And I quickly responded, I know that's your opinion. I'm just trying to figure out what facts led you to that opinion. And I still have had nothing on that one. She will not answer it.
She can't. There is no connecting facts. There are no facts that connect your physical location to the Constitution. That's why she's not able to respond with anything, anything other than a dodge. She doesn't have it. So again, for those listening, so what you can also do is you can say, ma'am, you just keep repeating your argument. I know what your argument is. You think if I'm physically here, your Constitution applies to me. I understand that. Can you please show me what evidence you have that proves that that's true, that just because I'm physically here, your Constitution applies to me?
Yeah, she also pulled a little fast on me because I didn't catch it fast enough. But she mentioned, because I filed a motion to dismiss with the Poe versus Olin or Oler, either way. She mentioned, well, that's a birth control case. Are you aware of that? I'm like, yes. And she rambled on and did give me a chance to respond with the whole due process with the Supreme Court's decision on that either. She just moved on and said, birth control case not relevant, only applies to the Supreme Court.
Yeah, this is a very common thing, and it's something that if you get the opportunity, hold on just one second.
Times are off.
I still had that show up. Okay, so if you have the opportunity, you can throw that crap right back in their face, because chances are the cases that they're citing have completely different subject matters. But what you can do after that is bring back, well, the ruling in Poe, wasn't that regard that you're talking about, because there's several rulings there. Isn't the ruling that we're talking about, that whether the court system is adversarial and what the requirements are for an adversarial proceeding? Are you telling me that only has application in birth control cases, or is that just general application to the court system as a whole? What this is the same stupid thing, Sean, that prosecutors have given me when we use the Shaw case to lay out exactly what prosecutorial misconduct is. That is arguing without evidence. And they'll turn around and say, but the subject matter was completely different there. But yes, but the ruling of what is generally considered to be prosecutorial misconduct is this broad application. It's like saying, well, you can't quote something from this particular case. That was a murder case involving somebody shooting his wife in the head. This is a strangulation, you idiot. I'm like, but that's not why we're citing it. So all it is a stupid straw man. That's all that it's a distraction. Because remember, like I've said, most of what attorneys say is a distraction and a dodge from the actual issue that you're raising. So to say that the ruling in Poe that we're using has no application to the courts in general because the underlying case was birth control. Come on. The thing is, that's an opportunity for where I would probably say, have I done anything to lead you to believe that I'm retarded? Oh, I haven't? Well, could you stop treating me like I'm half retarded and actually treat me like an adult and address the issues and not try to do these stupid lawyer tricks and to try to deflect attention away from the actual issue? Hey.
She actually managed to ramble on for a good 5 minutes, getting off of that topic as quickly as she could after she mentioned that too. And then she mentioned points 5 and 6, which no evidence that the laws apply to me because I'm physically within the state. And then she was like, well, there's no court cases cited there, so you have no evidence to support that. I'm not asking for, I don't need evidence to support that. I'm trying to get you to show that you have evidence to prove subject matter jurisdiction.
So she's making this, again, this is a stupid lawyer distraction. She's trying to defeat your argument by trying to point out that you don't have a supporting case cited to show that she has to have evidence to support her claim.
Precisely.
Wow. That is, the thing is, and maybe I could put that in there just as a knowing, so we can put something in there just like it's a preemptive thing, like which a lot of the motion to dismiss is preemptive. The last point is preemptive because we could just put in there the ethical rule and also put in the Shaw case that arguing without evidence is prosecutorial misconduct.
I would agree with that, and I would say this case went pretty good because I've been trying to. This has been going on since March 15th. My first trial was in May or April, but anyway, I've maintained that I want to plead guilty, and she has not once tried to enter a plea on my behalf. So as far as her forcing me, I'm pretty sure I'm good on that. It's just she does not want to give me any factual evidence. She just wants to assert the jurisdictional issue.
Yeah, in fact, to continue saying that physical location means the Constitution applies. I mean, that's something that you want them to be specific on. So that you're addressing their actual argument. And,
yes, and so far, the only thing the prosecution has given me, well, not even because it's just me, the cop, and the judge. The only evidence that I have is a ticket. And every time I try to get more evidence, they issue me another ticket.
They want to give you another ticket because you're asking for evidence.
Get factual evidence. I just get tickets.
Oh, you're getting a copy of the ticket.
No. I'm getting more tickets. Every time I meet with the officers or tell them to meet with me to give me evidence, they just issue me another ticket. That's the only evidence they give me is just another ticket.
So they're giving you multiple charges now?
8 tickets from one officer. Yes.
So what's the additional charge?
It's basically the same thing. I have an expired tag 6 months, and the officer Iversi just keeps giving tickets and tickets and tickets.
Oh, so he's giving you a ticket because every time you go to the court, you're in an automobile that has expired tags. Correct. I got it. You need to get an Uber or have someone drive you there to avoid having these people because this is. I mean, they could really stick it to you good. So you've got how many tickets now you're fighting?
9 tickets, 2 cops.
Holy, yeah! You gotta cut these people off. You have to stop showing up to court in a car, so like that. So even it's
not just me showing up to court in a car; it's just me driving around. It's the same. They know that I'm a nighttime person.
Yeah, I think here you're in a really bad spot. So I think I would bite the bullet and I would get the tags current. But let's so I would do that. But let's get to 9. You're getting into Mark Stevens territory there with so many charges for traffic. Wow,
legal land is fun.
Yeah, well, doing things like that landed me right in the seat 20 years later doing this and helping other people get through these these situations. So, wow. Okay.
Yeah, I have a third arraignment attempt scheduled for August 16th with both of the officers and all the tickets on the table this time.
Well,
still trying to interplead guilty.
And if they can't make out the if they can't prove jurisdiction and personam jurisdiction and subject matter jurisdiction on the one, that applies to all of them. So now you've got okay. So was there a ruling on the motion to dismiss? I'm guessing that they probably denied it.
Yes, they denied all of it. And then when I asked regarding personal knowledge of the witnesses, the judge said on the record, they don't have to have personal knowledge. They don't have to know they had jurisdiction. They just have to believe they did have it. Like, they just have to believe they had it.
Wow. Doesn't need. Okay. You have to file to get rid of to recuse this judge.
Yeah, I'm going to need one of those motions. I got to find one.
I have a template available. And so what you're going to have to do is you're going to have to show the facts regarding why you to support your claim that this guy is so biased against you that he can't be fair. And on that alone, that the police officers can make claims against you and testify against you and don't need personal knowledge. It goes right against the rules. He's not holding him to even a minimum standard of competency and credibility. So on that alone, and then also saying about jurisdiction is assumed, that also you cannot get a fair trial when they're not holding them to their burden of proof.
Yeah, it's actually a female judge, and she's only been a judge for 1.5 years, and one of the officers has only been a cop for 1.5 years.
Yeah, well, it's lucky for them that they've got this compliant judge. So I'm actually, if it was a Saturday show, I'd keep you on a bit longer, but we're loaded up with calls and I only have a half hour or little. Yeah, we're almost halfway done with the show. So that's what, email me, get a copy of the motion to disqualify the judge. And have you filed the Brady request with the police officers since there's no prosecutor yet?
Not yet. I've been trying to resolve it at the arraignment level, but unfortunately that's going to have to do. I'm going to have to do that.
And I appreciate that. I do. I think we're all trying to do that. You still have to try to get some leverage on them and file the discovery request with the Brady request so that you can also bring out the prosecutorial misconduct. If there's no prosecutor and the police officer is acting as the prosecutor, they're on the hook for the Brady material.
And that's the funny thing. Every time I ask them for evidence, they refer me to the state. And I had to point that out to the judge at my first arraignment. Like, they keep referring to the state. There's no prosecutor for this case. I'm just wondering who has the evidence and what it is so I can enter an informed plea. Yeah.
Well, don't, just for you and everybody else listening, don't let them kid you. You object and you call them out on that. Okay. Doesn't mean they're going to do the right thing. And you're going to have to file the motion to dismiss for prosecutorial misconduct. And it may have to be an issue that's raised also on appeal. If they're in a situation where the police officer is acting as prosecutor, he is responsible for discovery, he or she. They're also responsible for the Brady material. Nobody else is responsible for that Brady material except for the one prosecuting the case. The judge isn't responsible. The state attorney's not responsible. The county attorney's not. If the county attorney or city attorney puts in a notice of appearance and actually starts prosecuting the case, until that point in time, they have no responsibility whatsoever on the Brady. It is on the police officer's shoulders. So if they don't want to give it to you, file the motion to dismiss for prosecutorial misconduct. Also file to have the judge recused. If they're both denied, then let me know, because the benefit of doing it that way is you can file for a petition for writ of mandamus in the higher court to review the denial of the motion to recuse the judge. Okay.
Yep, gotcha. Long-time listener, 6-month practitioner.
Well, I'm hoping that you've done pretty good. Got some good admissions from them, and so hopefully we'll work with you through this and we can get you to a good resolution.
Appreciate the time, Mark.
All right, thanks, Sean in Florida. Yeah, that's the thing. Unless you're an activist, it's better off to have the tax tags current so you avoid possibly getting shot or beaten on the side of the street. And because even when you have the current tags, if they're in a regular habit of coming after you and know that you're a guy that makes objections and challenges these people in court, it could be a regular part of your life being stopped by these people. So Again, unless you are an activist, I would not do that. We got Ben in Colorado. Welcome back to the show. You got good news for us? Ben in Colorado.
Yes.
Welcome back.
Yes. Yes, thank you. So I went to court yesterday and had the arraignment, and the judge was pretty much immediately after I refused the offer from the city attorney, he started badgering me in the court and immediately started threatening me with contempt of court. He even called in the sheriffs and said, okay, you can talk to them. And when they came in, I pretty much asked, I was like, are you a party to these proceedings? No. Then I was like, I can't talk to you. And pretty much they put some paperwork in front of me to sign where I lose all my rights to everything pretty much. And of course, I refused to sign it.
But, okay, but Ben, what exactly was the judge threatening you contempt for? I mean, he
didn't say for what.
Well,
he said I'm not listening to him.
I
couldn't even speak, but he's saying I'm not listening to him.
He's threatening you with contempt because he said you were not listening to him?
Yeah, like every time I would try to speak, he would be interrupting me, so then I'd have to wait. And when I would try to speak, he's like, stop talking over me. You're interrupting me. And I was like, I can't even speak. So.
Okay. Did you ever interrupt him, or was he just pulling a douche move and interrupting you and then accusing you of interrupting?
That's exactly what he was doing. He was trying all these tactics to break me down and get me to listen to take the plea deal, essentially.
Well, all right. Can you tell us what the plea deal was?
The plea deal was just my ticket was 6 points. They're going to give me 3 points off, and he did not mention anything about how much money it is. So I said I can't accept that deal.
Okay. Well, I understand, because 3 points could still cost you a few $1,000s.
Exactly.
Wow. Well, and now had you already filed a motion to dismiss?
Yes, I filed both motions, the dismiss and for material and discovery, and they were both denied.
Whoa, wait. Okay, so the judge denied the motion to dismiss. Who denied the discovery request?
Well, I had filed the paperwork before going in there, right? So, right. Oddly enough, they mailed back the motion for discovery to me, citing traffic rules in Colorado 8A and B, which doesn't make any sense. But surprisingly, I never got back the dismiss one that was denied. It never came back to me.
So are they trying to say that because it's just a minor traffic misdemeanor that they don't have to give you the discovery prior to, unless it's immediately prior to trial?
Well, they didn't explain that. I mean, they did not say anything about that, actually. So I actually walked out of there in a not good state, in my opinion, because they pretty much set the whole thing for final hearing.
Okay. And did they say that you would get the discovery immediately prior to hearing?
No, they didn't say anything.
Okay.
So can I read those? Is my question.
Well, what you're looking at is two things here. Just like in Arizona, it's probably where on a misdemeanor like this, they don't have to give you. Well, actually, no. In Arizona, the misdemeanor, they have to give you pretrial discovery. On civil traffic, they don't have to give you discovery before the hearing. They just have to give it to you immediately prior to the hearing. So because it's a misdemeanor, they have to give you the Brady material when you request it. It's not one of these things, well, we could just withhold it until the day of trial. No, they have to. They have a reasonable time to then get to respond to that. So how many weeks has it been since you filed that?
I filed it since. Well, they sent it back to me on June 28th.
Okay, so they had plenty of time. All right, plenty of time. Okay. So
yeah,
what I would do is, because it sucks because you had the opportunity to speak with the prosecutor before, before the arraignment when they were talking about a deal. At that time, did you ask them about the evidence they rely on and the witnesses with personal knowledge? Did you press them on that?
I did not press them on that because I wasn't sure it was a court of record, because they sit at a table and whisper while other people are talking to the judge with their deals,
Yeah, for you and everyone else, every time you have the opportunity to speak with the prosecutor, I don't care whether it's on the phone, outside the courtroom, in a pretrial conference, whether it's on the phone, it doesn't matter. That is always our opportunity, because remember, our focus has got to be 100% on the prosecutor's evidence to support their claims. So wherever we happen to be, court of record, court not a record, take the opportunity, because you're not going to get that many. Take that opportunity to back them up into a corner on the evidence that they rely on. Because if they're talking about a deal, because then you would have been able to say to the judge, hey, not for nothing, I'm more than happy to plead guilty right now and take whatever deal the prosecution's willing to throw at me. I just want to know if they've met their burden of proof on jurisdiction, personal and subject matter. That's what I want to see.
Well, I asked him, and he just kept on. I asked the judge that, and he just kept on saying, "Oh, they have jurisdiction. Trust me, because the address is in Denver, Colorado. This and this." And he started reading the address to me and just taking up more and more time in the court. And then when he realized, I kept on saying, my intent here today is to plead guilty. How is the court establishing jurisdiction over me? And then when he realized I asked it like 2 or 3 times without getting an answer, he just enters a plea for me, and all of a sudden it was just over. And he's telling the lady, the clerk, please schedule a final hearing for him. And then they bring out a piece of paper for me to sign, basically where I waive all my rights. So of course I didn't sign that.
Well, yeah, and I don't blame you for that. Yeah.
So what is the move, you think, at the final hearing?
Well, I would file the motion, and you can email me after the show. I'll get you a copy of the motion to dismiss for prosecutorial misconduct, and I would make that the first thing that I talk about when I get to the final hearing. Now, this is in addition to you role-playing and prepping for that, because they're going to want to go as quickly as possible on that day and get that cop on the stand as fast as humanly possible, so they get this over with and make it look like they've given you a fair trial. So you want to be able to discuss the prosecution's lack of evidence and get some dialogue on this, that just, you want to pin them down. This is part of the Socratic method, very important part. You said last time, and I need you to be very, clear here so I can properly defend and effectively defend myself. You're telling me that my physical presence in Colorado proves the Constitution applies to me and gives you jurisdiction over me. And then you want to follow that up with, well, objection. I don't see anything in the record that would prove that that's true. What are you basing it on? What in the record are you basing that on? And because it's the final here, it's the trial, they may say, look, we're not going to discuss this. This is a jurisdiction's a trial issue. You'll have to take that up, during the trial. And that may be what, you have to make your objection. So then when they go to put the witness on the stand, you have a serious Brady violation, which is part of the prosecutorial misconduct motion. You guys got to stop interrupting here. So you have to go through the role playing so that you know how to properly object and deal with the responses. And when they go to put the cop on the stand, you can object based on the serious Brady violation that there's been no evidence submitted to show that the witness has personal knowledge of the matter she's testifying to. He has no personal knowledge that the Constitution and Code apply to you. So just like the last caller, the judge actually stated that the cop does not have personal knowledge and is trying to say that he doesn't need it. But that's part of the rules. That you would get the judge violating Rule 602, which requires the witness to have personal knowledge and requires that before they're on the stand that they have personal knowledge.
Okay. So would it be helpful to refile those discovery and dismiss motions again, or?
Well, you can refile the motion to dismiss as a motion to reconsider the denial. And so what you could do is you could put your issues in that the judge did it arbitrarily and only restated the prosecutor's argument, not that there was actually any evidence to support it. The argument is, we've said 1,000 times, if I'm physically, just because I'm physically in Colorado, the Constitution and code apply. That's the argument, but they have no evidence whatsoever to show that's actually true. Because to just say, X equals Y, that your physical presence in Colorado proves the Constitution applies to you, that's a non sequitur. Because it may be drawn out to where you have to actually ask the police officer that on the stand. Sir, you've testified that the laws apply, that just because I'm physically in Colorado, you believe the laws apply. Is it that your understanding? Is that what led you to stop me? Yes, because you saw me in Colorado and you determined the laws apply. Okay, so you determined that just because, and so once you get that admission, so what evidence, if any, did you rely on to support your observation or to support your claim that just because I was physically physically in Colorado, your Constitution applies to me?
So, well, the judge started reading the address off the ticket of where I got the ticket when I said, how does the court have jurisdiction over me?
Yeah.
So, and then he's like, there's the ticket and here's the address of where you got the ticket, essentially.
Right. It gives what he's doing. That's why I said before to object to that and say, is it really your position that if I'm physically in Colorado, then your laws apply and that gives the cop jurisdiction? And jurisdiction, from the cop. Once they agree, they go, I understand that is the prosecution's argument. I get that. My question is, where is the evidence in the record to prove that that's true?
The evidence is the ticket. It's like a circular argument, right?
Exactly. And we already know that. I mean, I've done it before. So what exactly? And he may say your physical location. Okay. How exactly does my physical location prove the Constitution applies to me? What proof are you basing that on? And so, no, I just want to let everybody know we have not hit a new record yet. It's close. I think we need a couple more for a new record. So, but I'm very happy to see. Actually, 94 might be a record. We had 94 going, guys. So, all right. So, I would like to spend more time, but again, I've got a line of callers, and we're running out of time. So, refile the motion I would refile the motion to dismiss as a motion to reconsider and show that the judge did it arbitrarily by merely repeating the prosecution's claim, which we already know, but not showing where in the record there was any evidence to prove that the claim was true. And I would file the motion to dismiss for prosecutorial misconduct because the prosecution seems to be hell-bent on putting a witness on the stand without providing any evidence that they have personal knowledge of the matters they're testifying to. And
but the issue is that they actually never, there was no rebuttal to the motion to dismiss. It's just, it just denied. There's no rationale, explanation, no nothing.
But the only rationale that there could be is that the judge is under the impression that the prosecutor has submitted sufficient evidence to support their claims. That's the, and so that's why I say that it's done arbitrarily, because there's nothing in the record to show as far as evidence to overcome the motion. So if we're saying that there's no evidence to support the claim that just because you're physically in Colorado, the Constitution applies, there's got to be, we're saying there's no evidence to support that. They could argue that evidence isn't required, which sometimes they do. But remember, it's an element of the charge. The laws applying to you because you're physically in Colorado is an element of the charge. Because they're charging you with a code violation, and they're saying, "Well, you violated the code." Well, it has to apply in the first place, and being that it has to apply, and they're testifying it applies, there has to be evidence to prove it beyond a reasonable doubt, and that's why we do that. So, but I do appreciate the call. Get me off air. I'll get you some of the templates, and definitely get into the No State Project Skype chat so you can do some role playing and prep for that big day.
Thank you, Steve. Appreciate it.
Actually, it's Mark. Yeah, okay.
Mark.
No problem.
Sorry, Mark.
All right, no problem, Ben. Well, Ben in Colorado will good luck. We'll hopefully get good news next time he calls in. Okay, let's see what we've got here. We've got Kevin. Kevin, welcome back to the big show.
Hi, Mark. How you doing?
I'm doing well. You got good news for us today?
No, not really. There's really no news.
It's one of those shows.
Yeah, I got my ticket in December, and then I think I had my hearing in like January or February, and then the first magistrate just found me guilty, and I called you, and after that, and yeah, they have whenever I filed the appeal, you go downtown, you have a totally new trial, and I filed the discovery motion with that, and trying to think, it was around April. We went down there. They didn't give me any discovery, and the cop just kept trying to get me to take the deal. He kept calling me outside like 4 or 5 times, and then we did it in front of the prosecutor, and he just tried getting me to take the deal, and I just kept asking for my discovery.
Okay.
And
did you ask him
so
questions regarding it?
And then about 2 weeks ago, I had another hearing.
Another hearing? Okay, we'll get to the hearing in a second. At these times you're talking with the cop and the prosecutor, are you putting them on the spot as far as being able to prove their claims?
Yeah, I was just asking. I think I did mention that, but yeah, they were just trying to get me to take the deal, and I was just like, I was just asking for a better deal or just to throw it out.
But will you
it'd be easier if you just throw it out.
Well, sure, of course. But you have to get some leverage on them. You have to pressure them by asking them questions. Do you have any evidence to prove your claim is true? Any evidence? What evidence do you have to prove that just because where is this happening?
I got it from a suburb cop, but it was, it actually happened in the city. I was right on the border. So I was actually in the city.
Where is this happening now?
In Pittsburgh and Brentwood. Brentwood's the suburb.
Okay.
On the street. I went through the red light.
Okay. Well, what you're asking them why you're putting them on the spot is you want to know what evidence they have to support their claim, that they're claiming that because you're physically in Pennsylvania, their laws apply. Do you have any evidence to prove that that's true? Can you prove that that's true? You're not even in court. It's not a matter of what the judge may or may not allow you to get away with. That's a separate issue you can discuss with them. It's why they're so confident the judge won't make them prove their case. But you need to be able to, I believe it's very effective, and we need to do that when you have the opportunity, just like the previous caller, when you have the opportunity to speak with the police officer and the prosecutor, and they're actually interested in the deal, get some leverage so that they're willing to give you a better deal than they're offering. Otherwise, they don't care. Yeah, they want to make a deal because that's all they want to do. But they're not going to make a deal that's in your best interest. Just like when we were talking with the previous caller, I think it was Ben, they still wanted 3 points on his license. So you got to get some of that leverage. Can you prove this? I've done it many times where you got them face to face, or you're on the phone, and you get them on the run. Where they'll turn around and they'll just say stupid things to you, Kevin. Well, put your question in writing. I already did, you jackass. What do you think the motion to dismiss and the discovery request is? I'm telling you, I'm asking you for this evidence. So because they're interested in the deal, they may be more, you do something like that in person and you're at the court and you're like, they may be saying, you know what, $75, no points. Let's get this over with. But you got to put them on the spot and give them more of a reason to deal with you. And just saying it's easier to drop it, hey, that works for me, but that's not going to do so much on that, for them.
Well, at the time, I showed the prosecutor that I had proof that I was in the city, not in the suburb, that the street's actually in the city. And I had pictures of the city trucks, like filling potholes on the street and service requests from the city. And he said he was still going to go through. He said the cop really wanted to go through with the prosecution. And he was just going to do what the cop said. And I was like, well, aren't you,
Wow.
can't you overrule the cop and stuff? I go, you're just wasting our time. And he like giggled, and he goes, that's what we do. He goes, we have all the resources to waste people's time. And he kind of like chuckled.
He chuckled. Wow.
He just didn't really care. I mean, he was just like nice. He's just like an old guy. He just, I mean, I don't know.
Well, yeah, I've seen that before. I had a guy here in Mesa, Garcia, who liked to chuckle and laugh at things, and he was the guy. The last time I was to court out here, he was the one that said that the ticket was evidence of jurisdiction, and I got him to reverse that and said that the ticket is not evidence of jurisdiction. So anyway. Well, let's. Wow. Okay, so you've got a hearing coming up, and you filed a motion to dismiss again, and the Brady request. And remind me, what responses have you got, if any, from that in writing?
About like 2 or 3 days before the hearing, they sent me a packet in the mail. They just said the public works director from the suburb in Brentwood was going to testify that he was going to prove that street is in Brentwood. And they sent me some maps, some real estate maps. They actually show that the streets in Brentwood, the real estate maps, but yeah, that's pretty much all they sent me.
That's not the best way. That's not the best way to, I think, to go about it. I think I would, for the motion to dismiss and the discovery request, and if they haven't responded properly to the discovery request and the Brady request, I would file the motion just like I mentioned to Ben in Colorado, I would file the motion to dismiss for prosecutorial misconduct, and definitely get into the Skype chat. I'm at Frank Rizzo 3. I could put you in. And start doing some role playing. Tom is bringing up a good thing we haven't mentioned here in a while: the going into court with as many people as you can as witnesses, and having the media reps like we've done. And what the hell is wrong with me that we haven't mentioned the media reps in quite a while? So appreciate. I don't think Tom mentioned media rep, but that's where I took. Yeah, we haven't been doing it. So if for those listening, if you can get someone to go with you to court, as a media rep, just there to observe, it certainly helps. In our experience, what we've seen, it keeps the judges from yelling and screaming quite as much. So that is certainly a help, and makes it easier for anyone to deal with these people when the judge is at least being like this guy and being even tempered. And the giggling sounds kind of creepy to me, but hey. So that's what I would do. And if you need, get with me off air, and I can get you the motion to dismiss for prosecutorial misconduct template, and help you get that finalized for filing. So I'm going to try to get one more call in now. Okay.
Oh, okay.
All right. Yeah.
Well, I was gonna let you don't want to hear about the hearing for the discovery that I had, or want me to call back on Saturday?
You know what? Can you make? All right. Let's hear it.
Well, I could just file your motion and then see what happens from there, then call back later.
Okay. Well, you know what? Can you do it in 2 minutes?
Yeah.
Okay. I'm sorry. I wrote it down. Okay. We were going to get back to that, and I'm sorry we got into a number of other issues. So.
Okay, yeah, you can take another call. It's no problem.
Well, we'll just take another minute or two and just give us the cliff notes.
Yeah, we went in there, and for the Brady request, he pretty much ignored everything. Oh no, that was the discovery. He just the judge and stuff really only cared about the camera and stuff. The cop told him he had no camera footage inside the car. And then I said, well, there's a camera right on the telephone pole right there. And the cop said there wasn't. And I had a picture of the telephone pole with the cameras. And then the judge told them they had to provide me that. And the cop was like, well, it's probably gone. It's been 6 months. And I was like, well, I filed the motion like 6 months ago. So they had this much time to provide it.
Yeah, that you could, if they don't have it, you could say, that looks like felony destruction of evidence. You can claim that it was 6 months ago, but I clearly have in a record the motion was filed 6 months ago. So, hey.
Yeah, I mean, I've listened for years. I definitely wasn't prepared. I was just hoping they'd throw it out, or the cop didn't show up. So, I mean, even though I've listened for years, it probably would have helped if I did some role playing.
Yeah, it certainly does help. All right, well, I appreciate that. yeah, let us know what happened. Get into and start doing some role playing, and get some people to go down with you to act as as just to even be witnesses. They don't have to say anything, but at least one of them to be able to say that there is a media rep doing a series of shows on judicial and prosecutorial misconduct, and you're there to observe and put someone on. Again, the tension's not as high, and so it's easier to defend yourself. So.
Yeah, and then he said the cop didn't have to provide any Brady information. It sounded like he was going to tell the cop he had to. He was questioning him and the prosecutor about it for a while, and then he just ruled that he didn't have to provide any of that.
Yeah, that's pretty
bad.
Well,
I'm not going to provide any evidence. I go, so I need the Brady information to try to, disqualify the cop whenever I cross-examine him.
I'm going to also, just like with the previous, we're having a lot of the same issues here today. I would also get with me off air, and I'll send you remind me what I'm saying here on the show that you need, because I'm going to forget as soon as the show's over. But you also need, in addition to motion to dismiss for prosecutorial misconduct, you need to a motion to recuse that judge. He's actually saying the cop is not responsible to give you Brady material. If there's no prosecutor on the case, the cop is responsible to give that to you.
Okay.
All right. Appreciate the call. We're going to try to get to one more call here. We have Chris in Texas. Welcome to the big show. What do you have for us today?
Hey there, Mark. It's kind of bad news. It's kind of the same trend. Went to court.
All right. I'm just going to mute you up then.
Okay.
No, I'm kidding. I just figured if I said something like, you know what, we're gonna not take any negative calls. It would make the trolls' heads explode. But what happened?
Right. Well, I went to court. I filed the motion to dismiss based off of the laws that apply to me, Constitution and Corpus Delicti, and then the Brady and discovery request.
Okay.
Went to court. This is my final hearing. They told me that by law, they're not required. An officer is not required to give any kind of information, because I asked for video recording, audio recording, certificates for his training, all that good stuff. And so when I get to court, the first thing the prosecutor does is ask for judicial notice, saying that it's a basis of law that the Constitution applies to everybody. And I objected, and I said, if it's judicial notice, it should be common knowledge, and everyone should know how it applies to them. And the judge sustained the judicial notice. So I tried to sneak in a question. Obviously, I got caught, and they told me I couldn't argue that fact. I couldn't ask that question because the judicial notice has already been established. So the only thing I really had to go from there was, his certificates and the recordings and all that good stuff. The officer all day long was, I don't know, but he knew that I was the guy that was speeding. He couldn't even describe my car without notes. I objected to that.
Okay,
and,
well, let's get back to this. What questions were you asking him on cross-examination that were not allowed?
Well, I asked him, okay, so I asked him, so you're a witness with personal firsthand knowledge, is that correct? He said yes. And I asked him, okay, so what evidence or any kind of evidence that you rely on that the Constitution could apply to me, just because I'm physically in state or I'm in your county? Well,
you should always say, and you should always use lay terms. Don't use county or state. Always say physically in Texas.
Okay.
So
the judge interrupted and said judicial notice was already established, or was already made aware of. So I couldn't ask those questions.
Okay, so it's a denial. They're using the judicial notice to settle an issue of fact that is part of the element of the charge that has to be proven beyond a reasonable doubt, and he's not allowing questioning of the witness. So you still have a denial of cross. And what they're also doing here is they're treating the prosecution's claim as irrefutable, which obviously denies you a fair trial.
Right. So I asked the judge, I said, okay, this is an element of the charge. There has to be a basis. If that's the case, the basis has to be that the laws apply to me. So I'm asking, what kind of evidence Sir, judicial notice has been applied, or however they said it. They said it in a certain way. I forgot what he said, but pretty much judicial notice is apparent.
Okay,
and I
so
said, okay, so
okay, I'm sorry for interrupting. I just I'm getting low on time. The issue with jurisdiction,
Yes,
with the issue with the taking of judicial notices, they have to present the evidence that it's based on. It's not a get out of jail free, or it's not a I don't have to prove my case. It has to be based on adjudicative facts that are well within the common knowledge, as to not be subject to reasonable dispute.
right. And then I moved my questions to the prosecutor. They got upset, and I said, so I looked at the judge and I said, well, I need the prosecution to show that on the record, on its face, what evidence that they rely on. And obviously, the prosecution said that I was testifying. I don't know how that was testifying. I just asked for a simple explanation and proof, because that's what we do, and that's the rule of a lawyer. You can't argue without facts. So so I pretty much just got shut down there, left and right.
Right. Well, what you want to, I just want to read the definition of judicial notice, which is pretty much what I said, because it's a fairly common thing. And this is what we need to show, because not only is it judicial notice is a rule in the law of evidence that allows a fact to be introduced into evidence if the truth of that fact is so notorious or well known or so authoritatively attested that it cannot reasonably be doubted. You were not in California at the time, right?
That's correct.
So you're talking about adjudicative facts. In California, they can take judicial notice of court rulings and what the laws actually say. Here, we're talking about judicial notice of an adjudicative fact. They were taking judicial notice of a legal opinion and then holding it as irrefutably true. So they misused, of course, the judicial notice. So that's what you want to bring up in a motion to post-conviction relief, because you were convicted, right?
I was convicted, yes, sir.
So you can have post-conviction relief and show that it was on, and obviously you're probably going to have to still appeal that. But you have where you want to lay out exactly what I just said. It's in Wikipedia. You can get it right from the rules of evidence, that they took judicial notice of a prosecution argument and held the argument as irrefutably true, as opposed to trying the right thing to do is to take judicial notice of an adjudicative fact. Okay? Because
right.
even your physical location. Sorry?
I was expecting that, and I read the definition to him. I just didn't say that they were taking it as a legal opinion from the prosecution side. So I would probably have to do that.
So hey, props to you. I mean, great. You did the right thing, and they doubled down on it. They took so for those who are new to this, what the judge did was take judicial notice of a prosecutor's argument and held that it was irrefutably true, and he couldn't cross-examine the witness on it. And judicial notice is for adjudicative facts. I have never even had reported to me, Chris, ever where they took judicial notice of the defendant's physical location during the stop. They always had to put the cop on the stand to prove beyond a reasonable doubt where you were physically located at the time of the stop. To take judicial notice of an actual element of the charge, do not go.
It was pretty gnarly.
Texas.
So it kind of threw me for a woozy there. So I had to take some time to recoup my thoughts, and my thought process went astray after that. But I still asked them about the corpus delicti. I said, so who am I actually harming? Did I harm you? No. Did I cause you any kind of loss whatsoever? No. Well, and then he started stating the facts about the 545, the speeding definition. And I said, well, can you describe my driving manner during that night? And he's all like, well, you're speeding. And that was it. So was I driving any erratically or anything like that? Pretty much. He admitted that I didn't harm anybody. So I asked him, so what are we doing here exactly? Because technically we're here because there has to be some kind of controversy. Who did I actually create a crime against? well, it's the state. Well, I kind of got smart and I said, well, I think it'd be a constitutional violation if I can't face my accuser. So it says the state of Texas. I would like to speak to the state of Texas. Then.
Well, that's not a good way to go, Chris, because the cop is actually accused you, and you got to do that. I got to go because I'm totally out of time. But get with me off air regarding the motions to dismiss. Well, you need the appeal request and you need the post-conviction relief petition because that is really bad. But hey, it's Texas. So I'm glad. I appreciate the call. So this actually does stand as a testament against some of the critics. But I appreciate the call and get with me off air. So hopefully we can get you to a good resolution.
Okay. Yes, sir. I'll definitely do that. Thank you. I appreciate the time like always.
No
Everyone
problem.
Have a great day. You have a great day, Mark.
All right. Thanks, Chris. And it seemed to be the theme for today was train wrecks. Not all of them were train wrecks. I mean, Chris did pretty good. But here, as I've said before, what happened to Chris is solid evidence that he was in a rigged game, that absolutely nothing was going to change that judge's mind. Judicial notice is fine of adjudicative facts, not legal opinions, which is what he did. And to not allow cross-examination under the guise that, well, we already took judicial notice of the argument and the officer's claim, so you can't ask any questions regarding the evidence to support that claim. What the judge did there is say, Abba Fungul, Chris, okay, we're only doing this so that we can satisfy the appearance of due process and justice, so that we can say, the guy, he came to court. He had the opportunity to contest and make objections. He was able to cross-examine the witness. He had a fair trial. He lost. He's just crying. He's crying. No, that is a rigged game. Again, judicial notice is a rule in the law of evidence that allows a fact to be introduced into evidence if the truth of that fact is so notorious or well-known or so authoritatively attested that it cannot reasonably be doubted. Let me tell you something. To say that, all this crap about, everybody knows that the fact that they claim they use everybody knows the laws apply, which is just an appeal to authority, doesn't prove that the claim is true. And see, cannot reasonably be doubted. When somebody tells you it's the law and we don't need evidence, you can reasonably doubt whatever they're spewing forth. There's your reasonable doubt. We don't have to have evidence. There's your reasonable doubt. Calling out BS. That's what we do here on the No State Project. And real quick, I do appreciate everyone's time and tuning in today. I think we did hit a record. So, hey, that's great. I will be live on the Saturday show, so definitely tune in. So whoever we missed, tune in for that. And if you are going to court, do what you can to get support. We have my forum, and we have the No State Project Skype chat. You can come on the show. You can let people know the court and the time that you're going to be there so other people can come in. So if we were coming in with 15 or 20 people, if possible, that would be great. And some of them were there as media reps doing a series of shows on judicial and prosecutorial misconduct. And hey, we're just here to observe. That really does help. Not only does it keep the judges and prosecutors on a somewhat better behavior, but you can do better because they're not yelling at you and you've got people who do support you. So that definitely does help. So I appreciate everyone tuning in today to the big show. Again, I will be live. I want to thank, of course, Bill, good friend in New Hampshire, for his continued support. And of course, Dan, if you want to help support the show, you can do so at markstevens.net. And until next time, salud.